Okay, good morning. Good morning. Okay, we're going to jump right into this morning, and I won't keep you all very long. I know Granny happens to be live right now, so I expect we'll get a few people over on the replay. If you're able to make it while we're live, I really appreciate you taking the time to stop in this morning. I know it's a nice weekend before we've all got bad weather coming in, so let's go ahead and jump into this. We are going to discuss the intentional infliction of emotional distress, the expectation of privacy, and what one of the leading Supreme Court rulings were in 1988, and that was in regards to Jerry Falwell and Hustler magazine, and how this relates to social media. So let's go ahead and dive right in. Okay. As always, this is the disclaimer. Nothing in this presentation is to be taken as legal advice. This presentation is simply a visual guide discussing the First Amendment of the United States Constitution, providing case law, nuance, and scholarly input regarding the freedom of speech, the right to free expression, expectation of privacy, and intentional infliction of emotional distress as it regards to the public square and the digital landscape. As new cases are processed through the courts, new opinions are written, and laws may change as technology, culture, and society evolves. So, what's on the books today may be updated tomorrow. Always do your own research. And if you hear meowing, that is Kiki. She's on the hunt. Her sister Tessa is being a little bit of a mischief maker today, so they are futzing around. Okay. What what is it? Intentional infliction of emotional distress is a civil tort where a person intentionally or recklessly causes severe emotional distress through extreme and outrageous conduct. To win an IIED case, a plaintiff must prove the defendant's conduct was outrageous and extreme, intended to cause harm, or done with reckless disregard for the likelihood of harm, and the plaintiff suffered severe emotional distress as a result. Okay, and we have an important note. Sorry about that, I muted myself by mistake. Statutory and case law shapes the legal landscape for emotional distress. Statutory laws provide foundational legal principles and guidelines for filing and proving emotional distress claims. On the other hand, case law consists of judicial decisions from previous cases that interpret and apply the law. Reviewing relevant case law can offer valuable insights into how courts have handled similar claims in the past. An IIED, or an emotional distress claim, a plaintiff generally needs to demonstrate four elements: extreme and outrageous conduct by the defendant that causes severe emotional distress, and that the defendant acted intentionally or recklessly in causing that distress. The conduct must be so extreme that it goes beyond what is usually tolerated in society. Simple insults are not enough. The emotional distress must be so severe that a reasonable person could not bear it, and evidence like medical records or testimony from mental health professionals can support the claim. Examples of conduct that might qualify include extreme harassment, stalking, false threats, false threats of harm or to death or to a family member, and spreading malicious rumors to humiliate someone. The plaintiff must have experienced significant debilitating emotional distress. Causation. There must be a direct link between the defendant's conduct and the severe emotional distress suffered by the plaintiff. Medical records. If the emotional distress has led to physical symptoms, gathering of medical records to document the impact. Electronic evidence, such as emails or text messages, social media posts that document harassment or abuse. However, when speech is involved in the IIED claim, courts must consider the defendant's First Amendment right to free speech, particularly if the speech concerns a matter of public interest, as seen in Snyder v. Phelps. Supreme Court decision. In 1988, Hustler Magazine versus Falwell, and that would be the Reverend Jerry Falwell. The leading case negating an intentional infliction of emotional distress claim by a public figure is the Supreme Court's decision in Hustler Magazine versus Falwell. The ruling established that public figures and public officials must meet the higher actual malice standard to recover damages for IIED when the alleged tortious conduct involves protected speech. Falwell sued Hustler and its publisher, Larry Flynt, for damages. The United States District Court for the Western District of Virginia ruled that the parody was not libelous because no reasonable reader would have understood it was a factual assertion that Falwell engaged in the act described. The jury, however, awarded $200,000 in damages on a separate count of IIED, a cause of action that did not require a false statement of fact to be made. However, the United States Supreme Court, in a unanimous decision, overturned the jury verdict of the Virginia court and held that Reverend Falwell may not recover for intentional infliction of emotional distress. It was argued that the material might be deemed outrageous, may have been intended to cause severe emotional distress, but these circumstances were not sufficient to overcome the free speech rights guaranteed under the First Amendment of the United States Constitution. Simply stated, an intentional tort causing emotional distress must necessarily give way to the fundamental right of free speech. It must be observed that although Falwell was regarded by the U.S. High Court as a public figure, he was an individual particularly singled out or identified in the parody appearing in the Hustler magazine. Also, the emotional distress allegedly suffered by Reverend Falwell involved a reactive interest, an emotional response to the parody which supposedly injured his psychological well-being. Again, that was a reactive response to what was seen, what was read, what was published. Verily, our position is clear that the conduct of the petitioners was not extreme nor outrageous. Neither was the emotional distress allegedly suffered by respondents so severe that no reasonable person could be expected to endure it. There is no evidence on record that points to that result. Learned opinion. Professor William Prosser views tort actions on intentional infliction of emotional distress in this manner. There is virtually unanimous agreement that such ordinary defendants are not liable for mere insult, indignity, annoyance, or even threats where the case is lacking in other circumstances of aggravation. The reasons are not far to seek. Our manners, and with them our law, have our law have not yet progressed to the point where we are able to afford a remedy in the form of tort damages for all intended mental disturbance. Liability, of course, cannot be extended to every trivial indignity. The plaintiff must necessarily be expected and required to be hardened to a certain amount of rough language and to acts that are definitely inconsiderate and unkind. The plaintiff cannot recover merely because of hurt feelings. Professor Calvert Magruder reinforces Prosser with this succinct observation. There is no occasion for the law to intervene in every case where someone's feelings are hurt. There must still be freedom to express an unflattering opinion, and some safety valve must be left through which irascible tempers may blow off relatively harmless steam. This should be self-evident, but unfortunately, in this microenvironment of social media, everything is so reactive, and it's emotional reaction versus a logical or intellectual or thought out reaction. And as we continue into the presentation, we're also going to get into when you put things out on the internet, expect them to be reviewed or commented on. And if you present yourself in a way that someone may perceive it as unflattering or funny, silly, rude, outrageous, whatever adjective you can throw out there, people will comment on it. And that's something to be expected. Just like if you are out in public and you trip and you fall, some people may reach down to help you. In today's society, people will pull out their cell phones and record you and put you on the internet, or people are going to point and laugh. That's part of life. It's part of being in the public domain. It's part of being in the public square. It is no different now that the internet is considered and social media is considered the digital public square. Constitutional law, First Amendment case law. The public figure libel plaintiff also has the burden of proving that the alleged defamatory publication was false. See HEPS 745 U.S. at 775, Herbert v. Lando 441 U.S. 1, pages 153 and 176. Garrison v. Louisiana, case 379 U.S., pages 64, line 74, 1964. Pure opinions, no matter how injurious to reputation, are absolutely protected. This is the most recent. See Gertz 418 U.S. Court 339 through 40. First Amendment applies to false ideas. Further, absent transgressions of the New York Times standard, of which is the standard that most cases are viewed through the lens of, the Supreme Court has consistently held that even the most repulsive speech is protected by the First Amendment. Lynn v. United Plant Guard Workers of America, Local 114, and Bose Court versus Consumers Union, 1985. The Supreme Court stated that even when a speaker or writer is motivated by hatred or ill will, his expression is protected by the First Amendment. Garrison v. Louisiana. And that you can find that at this case, or you can go to the St. Mary's Law Journal on page 6. Your privacy in social media. What's your responsibility? Many courts have concluded, essentially, that once you post something viewable by anyone else on Facebook. Good morning, Autumn. Okay, Autumn says, let me put that on the screen for you. The day our opinions are policed is a terrifying ideation. Got a shower, but listening. Okay, thanks for the personal bit of info. All right, thank you for stopping in. I appreciate it, and I do hope you find the information beneficial. Okay, let me get back on track. Many courts have concluded essentially that once you post something viewable by anyone else on Facebook, you have forfeited any privacy interest in it. In one early social media privacy case involving MySpace, a court noted Cynthia's affirmative act made her article available to any person with a computer and thus opened it to the public eye. Under these circumstances, no reasonable person could have had an expectation of privacy regarding the published material. While the term friend, in quotes, seems friendly, your Facebook friends may not be your real friends. As one court noted, where Facebook privacy settings allow viewership of postings by friends, the government may access them through a cooperating witness who is a friend, again, in quotes, without violating the Fourth Amendment. The court in that case reasoned that when an individual shares a photograph with friends on Facebook, that individual has no justifiable expectation that his friends would keep his profile private. And any legitimate expectation of privacy ended when he disseminated posts to his, again, friends, quotes, because those friends, in quotes, were free to use the information however they wanted. And contrary to the prevailing belief in social media exceptionalism. Good morning, Monchichi. Thank you so much for being here. I hope you're doing well. And if you have any new woodworking, please let me know so we can go ahead and get that shared out. If you all haven't, please sub up to Monchichi. Okay, back to the slide. Contrary to prevailing belief in social media exceptionalism, social media activity isn't really treated differently under the law. A basic principle of privacy law for years has been your privacy rights depend upon whether you have a reasonable expectation of privacy. The reasonableness of your expectations has always been judged from a common sense totality of the circumstances, regardless of the physical or virtual area of the activity. Okay, one moment. I'm going to take a sip of water. Thank you for waiting. Specific to YouTubers and podcasters. Generally, no, a YouTube personality cannot successfully sue. Hello, Saint Outlaw. Thank you. I appreciate that. Generally, no, a YouTube personality cannot successfully sue a reviewer for invasion of privacy for discussing personal details the personality has already made public. By publicly sharing personal information on a platform like YouTube, the individual has likely forfeited their legal expectation of privacy regarding those specific details. Why reviewing public information is generally protected. The protections for reviewers are based on legal principles concerning consent and the balancing of privacy against freedom of speech. Voluntary consent. By posting details of their life online, the YouTuber has given implicit consent to the public disclosure of that information. What does that mean in legal terms? In legal terms, consent is a complete defense against an invasion of privacy claim. Limited privacy for public figures. While a YouTuber may not be a mainstream celebrity, courts recognize that public figures, by virtue of their public persona, have a diminished expectation of privacy regarding matters they make public. truth and public interest defenses. You're Chi-Chi, you're right. Absolutely. I've been saying this for a while, and I know there's been many people on social media that have said, it's one thing to blog or to vlog and do an IRL stream, um, where you're talking about your general surroundings, talking about what you've done for the day. Um, it's entirely another when you bring your family onto the platform, discuss intimate details of your life, or potentially embarrassing things about yourself, such as, I got picked up for a DUI, or I got pulled over for a speeding ticket, or, you know, um, show things that might cause viewers to have concern. And you open yourself up, and it's a shame that it has to be that way. That sometimes you might want to share things about accomplishments that your children have done, or a major life event. But again, in doing so, you open yourself up to scrutiny. And for good or for bad, that's how it is. And keep in mind that even offline, people that say run for local offices, or if somebody that is say a spokesperson for the local car dealership that just does, that does commercials on television, that's local, uh, again, become that limited public figure. And it's an interesting dynamic. But just because it's on social media, it doesn't change the fact that if you're on a soapbox or your bully pulpit, people are going to criticize and look into the individual, what they're saying, and what's their background, and so forth. It's a double-edged sword. It really is. Monchi Chi says, that's why I seem to be obsessed with wood. It's what I like to talk about on here. Family is not my content. Exactly. Same thing with myself. I'd love to be able to share certain milestones with of my grandchildren, or something, but they're not for public consumption, and you have to keep some things private. Um, at one time, I had wanted to transition my channel into a more of an educational channel. So I looked into what would be required of that, so I could be considered an authoritative source here on YouTube. And what YouTube required was that my government name and all my government credentials, or my licensings and certifications and stuff like that, would be part of the channel. That would be all listed underneath the homepage, or any designated videos or live streams. And quite frankly, that's not information that I want out and about on the internet. And as somebody that has experienced a very personal stalking situation in my life, I would never want to have that door opened again. So now I will give presentations, and we will have general discussion on them. And I open the door. You can go further and research these various topics that we talk about over here. And I really appreciate y'all coming in and giving your input, and that you are finding value in it. So sorry, I side quested a little bit. Back to the presentation: truth and public interest defenses. Reviewers can defend their statements on the grounds that the information is truthful and already a matter of public interest, provided they are not revealing other private, sensitive details. I do like a bit of light trolling of dipstick of dipsticks, all in fun. Yeah, exactly, Monchichi. All in fun. I had my days of being a bit of a troll myself. Now I'm too old for it, I guess. But I will be a little bit petty every now and then. The First Amendment remedy for unwanted speech, look away. We went over this with the First Amendment presentation. Simply avert your eyes to protect your sensibilities. The right to free speech includes the right to attempt to persuade others to change their views and may not be curtailed simply because the speaker's message may be offensive to his audience. One reason the First Amendment tolerates vulgar language is because offended viewers can effectively avoid further bombardment of their sensibilities simply by averting their eyes. Cohen v. California. And in the context of the internet, you don't have to listen. You don't have to watch. You don't have to open up that blog post. You don't have to open up that Twitter post. And it's impermissible to restrict speech when less restrictive alternatives are available. We are expected to protect our own sensibilities simply by averting our eyes when confronted with undesirable speech. Restricting speech when less restrictive alternatives exist is not permissible under the First Amendment, and that's U.S. v. Playboy Entertainment and of the year 2000. Hi, Cash. I'm glad you could make it in today. Cash, if you could do me a favor and pull Sane Outlaws link to her channel and Monchichi's channel. Would you go ahead and drop those links in chat for me, please? I would appreciate it. And here are some authoritative sources for y'all. I especially wanted to put in the viral spiral, how a minute of internet fame can lead to a lifetime of unwinnable defamation actions. I didn't pull up that organizational post because I want everybody to go and read it in its entirety. It's got a wealth of information, at least for this particular entry. Okay. I'm not promoting the organization in any way. I'm not co-signing anything with this organization in any way. I am simply providing the link for this particular article and this particular observation for it. I also want to touch on when we brought up the what is sniping, and we talked about implied consent and direct consent. Implied consent, again, is you're putting something on a public platform. Once it's out there, it's out there. You can choose to take it down, but once it's been consumed as content, people now have the ability to review it and comment on it. That's and YouTube it's broadcast yourself. Okay, that's what it started out as. Broadcast yourself. Put your videos out here. We got into streaming. Live streaming is being pushed more and more. You get very comfortable with your audience, so you share more and more. And as a result of that, goes back to relationships, and especially parasocial relationships, can break down. Somebody you once thought was a friend can turn around and take things that you've said in that you thought you were saying in private or that you've shared, can go and now start commenting or going out and sharing things. Now, the one caveat with this is I personally have a concern with private messages within the context of Facebook. A one-on-one communication is an electronic communication. However, when you start having a group chat, that privacy, is there going to continue to be that expectation of privacy because you now have more than one person involved? Would this be like having, say, a coffee break at the water cooler where there's 3 or 4 people around? Who all has access? What are the rules of electronic communications in your jurisdiction? So where something might fall out of on privacy when it comes to a private message, like in Pennsylvania. In Pennsylvania, we're a two-party consent state. So any email I send to somebody or any private message I send to somebody, they can't turn around and go and share that, because that falls under, I didn't give you permission to share that, and that falls under the Electronic Communications Act. That's considered diverting a communication. It's fascinating. Check with your own jurisdiction, your own state, your own location on how that works as far as private messaging, because I've seen recently that certain messages that were considered private or things that were shared privately are being used to go at another individual on the platform because there's been a falling out. That's individuals may want to look into that and protect yourself. Again, my golden rule: don't put anything in writing that you wouldn't want your grandmother or a 3-letter agency to see. It's that simple, you know. It should be common sense. It should be common sense, but unfortunately, it's not common sense. And let me go ahead and pull up. Let's touch on. Okay. I should have music breaks when I'm looking for something. Okay. Yeah, I have to go off platform because I don't have this loaded up into the Restream. I have it over in my OBS, and I'm not running OBS through Restream today. Is that this one here? Okay, yeah, here we go. All right. Okay, Cash, thank you so much for pulling all that up. And yeah, okay. What we talked about previously with the unclean hands, no clean hands, dirty hands doctrine, that the clean hands doctrine, also known as the unclean hands or dirty hands doctrine, is an equitable defense. This means it can be used to prevent a plaintiff from obtaining certain remedies if they have engaged in the unethical or wrongful conduct related to the subject or claim. So what we're being told in these C&Ds is that because of words that are being stated on YouTube live streams, that the individual that sent the C&Ds finds them offensive or abusive or harassing or it's causing her distress. Well, should this be something that's pursued? Keep in mind what we've just gone over with what the case law is, what the statutes are, what's already been litigated, what's on the books, and the unclean hands being an absolute defense, because this particular individual has engaged in the back and forth, the clapback, and also reviewing of that person's content. So again, it is this back and forth. As a reasonable person, I consider myself a reasonable person. I would say, as a reasonable person, that the claims made within these particular C&Ds may fall flat based on what I've witnessed thus far. Again, based on what, excuse me, based on what's available publicly, because I'm not behind the scenes with anybody, with what I've just seen publicly, it falls flat because the person that instigated the cease and desist has engaged in the same, if not more egregious behaviors through their online participation of YouTube. That's just my 2 cents, my opinion as a reasonable individual, a reasonable person. And I recently heard that, oh, no, medical records, they're not involved in any of this. Au contraire, mon frère. If somebody is claiming intentional infliction of emotional distress, that they are suffering emotionally, they are suffering psychologically, they are suffering, their physical health is suffering as a result of the claims that they are making, absolutely, medical records do become available to the defendant's team, to the judge, to the court, because the judge or a jury will not rely on just the word of the claimant or the plaintiff, on the person making these claims about themselves. There has to be documentation, and that comes in the form of medical records, mental health evaluations, and should certain things ever come to fruition to the bench, professional documentation is required to make these type of claims. And it's not, and yes, they do go back, not just days or weeks or months. They will go back overall. Again, I'm speaking, generally speaking, in a civil case, if one claims emotional distress and that their life has been severely disrupted, this needs to be verified. Your word is not taken for it. The claimant's word is just not taken for it. And so yes, certain records can be subpoenaed. Certain records will have to be made available. That's how the system works. And there's and again, it's case specific and it's claim specific, which will determine what will be required or requested. And so that's always something to keep in mind when you get involved in these type of things. Again, the bench doesn't listen to the claimant's words and say, oh, okay. No, that's hearsay. There has to be documentation. You have to have evidence of the facts that you're presenting to the bench. So, and maybe we'll take a case later. Right now, as you all know, I'm working a criminal. Oh, okay. Let me rephrase. I'm following a criminal case. So that's where my focus is right now, is on the criminal case of Jessica Mothy and the criminal homicide and the involuntary manslaughter charge of the woman from Ford City that birthed four children in her home and allowed them to pass away. So it's going to be an emotional case, and the preliminary hearing is September 30th, Tuesday morning. So I will be going to that, and hopefully she just pleads guilty and it'll be done with. That's my hope. I hope this doesn't go out to a trial, because it will be very, very disturbing for the jury, and for anybody that is personally involved with having to see the evidence that is involved in this particular case. Cash, I have it on my homepage. I put it up as a video under true crime, and I also put it in my podcast. It's my most recent video, I believe. So that's where. But what I was going to say is, perhaps we'll go ahead and I will see about pulling a couple of. See, with the civil cases, you have to make sure that they're publicly available to see what's all involved in that. Well, one of the most public civil cases that claimed emotional distress and defamation and all that was the Amber Heard and Johnny Depp case. So by all means, if you didn't watch that case, it was streamed for the whole world to see. You can see what's involved there. And granted, those are celebrities and actors and actresses, and things may have been a bit exaggerated here or there, but that's a good example of the type of questions that are asked, and how deeply personal and invasive bringing these types of claims can be. So, but with that, I'm going to go ahead and drop off. We've been going for about 45 minutes to an hour, and I appreciate y'all being here, and I will see you soon. Don't forget to, if you're not subbed up, go ahead and sub to the channel. Again, I don't do a whole lot of uploads. I don't have a regular schedule, but I do appreciate y'all being here. Anybody that comes in on the replay, please go ahead and leave a comment, a like or a dislike, what have you. Check out the source material, and let's see, anything else? Oh, keep updated on my community posts and also my Ko-fi. That is where I do the first looks or sneak peeks into upcoming presentations. Also, I have an X. I don't post over there too often anymore, but just to let you all know, that's where you can find me. And as always, you can see me out there on these chats when I'm out and about. So until next time, y'all be well, be joyful, and I'll see you around the next corner. Bye.